The day I came home to find a bright orange violation notice stapled to my front door, I knew my peaceful life in Meadowbrook Estates, Virginia, was about to become a nightmare. I'm Thomas Haywood, a 42-year-old software engineer who works from home, and I just spent the entire weekend splitting and stacking firewood along the side of my property. My back ached, my hands were covered in blisters despite wearing gloves, and I was actually proud of the neat rows of seasoning oak and hickory I'd arranged. The woodpile was about 6 feet high, 20 feet long, and positioned right where my property survey showed I had every right to place it. My house sat on 2 acres, and unlike most of the postage stamp lots in the neighborhood, my property backed up to an old apple orchard I'd purchased separately from a retiring farmer named Bill Henderson. The notice was dated that same afternoon, which meant someone had been watching me work, waiting for me to finish so they could slap this citation on my door. The fine was $500 for unsightly storage of materials and violation of community aesthetic standards. I had 7 days to remove the woodpile or face additional daily fines of $100. I stood there on my front porch, still wearing my work boots and flannel shirt, reading and rereading the notice. The signature at the bottom belonged to Patricia Harmon, president of the Meadowbrook Estates Homeowner Association. I'd met Patricia exactly once, during the closing on my house 3 years ago. She'd been pleasant enough then, welcoming me to the neighborhood with a rehearsed smile and a folder full of HOA documents I'd admittedly skimmed rather than studied in detail. That evening, I sat at my kitchen table with those documents spread out before me, a beer growing warm as I searched for anything about firewood storage. The covenants and restrictions went on for 47 pages, covering everything from fence heights to mailbox styles to approved exterior paint colors. There was a section about storage that prohibited boats, recreational vehicles, and commercial vehicles from being visible from the street. There was even a clause about garbage can placement, but firewood, not a single mention. I called my neighbor, Rick Patterson, who'd lived in Meadowbrook for 12 years. Rick was a retired postal worker in his 60s who'd always struck me as the reasonable type. "Hey Rick, it's Thomas from next door. Got a weird question for you." "Shoot," he said. I could hear a football game playing in the background. "You ever had any trouble with the HOA about firewood?" There was a pause, then Rick laughed. "Is this about Patricia and her crusade against your woodpile? You heard about it already. Thomas. She spent an hour this afternoon calling everyone on the board and several neighbors, trying to drum up support for citing you. She's been complaining about it since you started stacking yesterday morning. But is there actually a rule against it? Not that I know of. But Patricia doesn't always need an actual rule. She just needs to feel like something violates the spirit of the community, whatever that means." I thanked Rick and hung up, feeling my frustration building. I'd bought this property specifically because of the larger lot size and the rural feel. I heated my home partially with a wood stove, which saved me hundreds of dollars each winter and felt more sustainable than relying entirely on electric heat. The woodpile wasn't an eyesore. It was neatly stacked, covered with a tarp, and positioned well away from my house to prevent pest problems. The next morning, I called the HOA management office and asked to speak with Patricia Harmon. The receptionist, a young woman who sounded bored, told me Patricia held office hours on Thursday afternoons from 2 to 4. "I'd really like to speak with her sooner," I said. "I received a violation notice yesterday." "Thursday, 2 to 4, she repeated. "Or you can submit a written appeal." I spent Monday and Tuesday researching property rights, HOA law in Virginia, and specifically looking into agricultural exemptions. My property's deed included the apple orchard, which technically made my land partially agricultural. The orchard wasn't productive anymore. Most of the trees were old and needed significant pruning and care, but it was still classified as agricultural land for tax purposes. I'd gotten a reduced tax rate because of it. The more I dug into Virginia property law, the more interested I became. Agricultural activities were protected in Virginia under the Right to Farm Act, which prevented localities from imposing restrictions on normal farming operations. Firewood production and storage fell under agricultural use, especially on property already designated for agricultural purposes. Thursday afternoon, I dressed in business casual and drove to the HOA office, which was located in a small professional building near the Meadowbrook Estates entrance. The office was decorated with photos of the neighborhood, marketing materials that made our subdivision look like some kind of paradise, and a large map showing all the properties. Patricia Harmon was exactly what I expected. She was in her mid-50s, with short blonde hair styled in that specific suburban mom cut that seemed to be universal among women in positions of petty authority. She wore a cream-colored blazer over a floral blouse and had reading glasses on a beaded chain around her neck. "Mr. Haywood," she said, not standing up when I entered her office. "I assume you're here about your violation." "I am. I'd like to understand what rule I'm violating." She pulled out a copy of the covenants and turned to a page she'd marked with a yellow sticky note. Section 12, Paragraph 4. All exterior storage must be screened from view and maintained in a neat and orderly fashion. Section 14, Paragraph 2. No materials may be stored in quantities or configurations that create an unsightly appearance or diminish property values in the community. "My woodpile is neat and orderly," I said calmly, "and it's not visible from the street." "It's visible from the Mitchell's property," Patricia countered. "Diane Mitchell called me Saturday morning to complain. She said it looks like you're running a lumber yard." The Mitchells live 4 houses down. They'd have to be standing at the far corner of their property and looking at a very specific angle to even see my woodpile. Patricia leaned back in her chair, her expression hardening. "The point is, Mr. Haywood, that Meadowbrook Estates is a community that prides itself on maintaining certain standards. We're not a rural area. We're a planned residential community. Your woodpile, regardless of how neat you think it is not in keeping with the character of this neighborhood." "But there's no specific rule against firewood storage. The rules I cited are specific enough. The board has voted to uphold your violation. You have 4 days left to remove the woodpile or the daily fines will begin." I felt my jaw tighten. "Can I address the board directly?" "The next board meeting is in 3 weeks. My fine period ends in 4 days. Then I suggest you remove the woodpile and reapply for a variance if you want to store it differently." I stood up, keeping my voice level despite the anger rising in my chest. "I'll be fighting this violation. My property includes agricultural land, and firewood storage is an agricultural use protected under Virginia law." Patricia's eyes narrowed. "Your property is part of Meadowbrook Estates and subject to our covenants, which you agreed to when you purchased your home. Agricultural exemptions don't apply in planned communities. We'll see about that." I walked out before she could respond, my heart pounding. I'd never been the type to get into confrontations, but something about Patricia's dismissive attitude and the fundamental unfairness of the situation lit a fire in me. That evening, I contacted a property attorney named Michael Crane, whose office was in Charlottesville, about 40 minutes away. His website mentioned HOA disputes and property rights. His assistant scheduled me for a consultation the following Tuesday. Friday morning, I received a follow-up letter from the HOA, this time via certified mail. It reiterated the violation and included photographs of my woodpile taken from various angles. Someone had clearly walked around taking pictures, some from angles that required standing on neighboring properties. The letter also informed me that if I didn't remove the woodpile by Monday, the HOA would schedule its removal at my expense, in addition to the daily fines. I spent the weekend documenting everything. I photographed my woodpile from every angle, showing how neatly it was stacked. I photographed the orchard, the property lines, and the survey markers. I pulled up my property tax records showing the agricultural designation. I printed out pages from the Virginia Right to Farm Act. I even called Bill Henderson, the farmer I'd bought the orchard from, and asked if he'd be willing to testify about the property's agricultural nature if it came to that. "Course I will," Bill said in his gravelly voice. "That land's been agricultural for 70 years. Just because you've got a house on part of it doesn't change the orchard." Patricia Harmon tried to give me grief years ago when I still owned that property, wanted me to stop burning brush piles because the smoke bothered her. I told her where she could stick her complaints. Monday came and went with no removal crews showing up at my property, but another letter arrived informing me that daily fines were now accumulating. $100 per day, starting immediately. Tuesday, I met with Michael Crane. He was younger than I'd expected, maybe in his late 30s, with dark hair and an easygoing demeanor that put me at ease immediately. "So, tell me what's going on," he said, gesturing to a chair in his office. I laid out the entire situation, showing him the violation notices, my property documents, and my research on agricultural exemptions. Michael listened carefully, occasionally asking questions. When I finished, he leaned back in his chair and smiled. "This is actually pretty interesting," he said. "HOAs usually have broad authority to enforce their covenants, but there are limits. Virginia's Right to Farm Act does protect agricultural activities, and there's case law supporting agricultural exemptions even in residential areas when the property has a legitimate agricultural use. So I have a case. You have a strong argument. The key is proving that your firewood storage is genuinely connected to the agricultural nature of your property. Do you actually use the orchard?" "I'm planning to. I bought it specifically because I want to restore it. I've already started researching apple varieties and pruning techniques. The firewood I'm storing, some of it came from clearing dead trees in the orchard." Michael nodded, making notes. "That's good. That establishes a direct connection between the firewood and the agricultural use. Here's what I recommend. First, we send the HOA a formal response disputing the violation on the basis of agricultural exemption. We cite the relevant statutes and case law. We give them an opportunity to back down. If they don't, we take it to court. How much will this cost?" "My retainer is $5,000. If it goes to trial, there could be additional costs, but honestly, I don't think the HOA will want to go to trial. These cases don't usually go well for HOAs when there's a clear legal exemption involved." I thought about the $500 fine, plus the accumulating daily fines that were already at $700 and climbing. I thought about Patricia Harmon's dismissive attitude and the principle of the thing. I'd worked hard to buy this property, to make a home here, and I wasn't going to let an overzealous HOA president bully me into compliance with made-up rules. "Let's do it," I said. Michael drew up a formal response that afternoon. It was 3 pages of legal language that basically boiled down to this. My property had a legitimate agricultural designation. Firewood storage was a normal and necessary component of agricultural land management. Virginia law protected agricultural activities from local restrictions. and therefore the HOA's violation was invalid and unenforceable. We sent it via certified mail and email to both Patricia Harmon and the HOA's general counsel. The response came faster than I expected. 2 days later, Michael called me. "They're not backing down," he said. Their attorney sent a response arguing that the HOA covenants supersede agricultural exemptions, and that your property's agricultural designation is irrelevant because you're not actively farming. They're also threatening to accelerate the fines and pursue legal action to force compliance. So what's next? We file a complaint in circuit court. We ask the court to declare the violation invalid and enjoin the HOA from enforcing it. We also ask for attorney's fees and costs. How long will this take? Could be a few months to get a hearing. In the meantime, I'll file for a temporary restraining order to stop the daily fines from accumulating while the case is pending. The next few weeks were surreal. I went about my normal life, working from home, taking care of my property, and trying not to obsess over the legal situation. The restraining order was granted, which stopped the daily fines at $2,300. Combined with the original $500 fine, the HOA was claiming I owed them $2,800. Patricia Harmon apparently didn't take kindly to being challenged. Rick Patterson called me one evening to warn me that she'd been going door to door, talking to neighbors about my defiance of community rules. "She's painting you as some kind of anti-social troublemaker," Rick said, "saying you're putting your own interests ahead of community property values." What are the neighbors saying? Most people don't care, to be honest. A few are on her side, mostly the ones who live for this kind of drama. But a lot of folks are actually annoyed with Patricia. This isn't the first time she's gone overboard on enforcement. That comment sparked my curiosity. I started asking around, talking to other neighbors I'd been friendly with. It turned out Patricia Harmon had a history of aggressive HOA enforcement. She'd cited people for having the wrong shade of brown on their fence, for planting flowers that weren't on the approved list, for having holiday decorations up a day too long. Several homeowners had just paid the fines rather than fight, even when they disagreed. One neighbor, a woman named Susan Torres who lived 3 streets over, told me she'd been fined $800 for parking her hybrid SUV in her driveway overnight, because Patricia claimed it was too large and violated the commercial vehicle prohibition. "It's a Honda Pilot," Susan said, shaking her head. "I drive it to my office job, but Patricia decided it looked commercial and the board backed her up. I paid the fine because I couldn't afford to fight it. The more I heard, the angrier I got." Patricia wasn't protecting property values. She was on a power trip, using the HOA as her personal fiefdom. The court date was set for early April, about 3 months after the initial violation. Michael Crane filed extensive briefs, including expert testimony from an agricultural extension agent who confirmed that firewood storage was a normal component of orchard management. Bill Henderson provided a written statement about the property's history. We included documentation of my plans to restore the orchard, including receipts for pruning equipment and consultations with an arborist. The HOA, meanwhile, doubled down. Their attorney filed a brief arguing that allowing my woodpile would set a dangerous precedent, that other homeowners would claim agricultural exemptions for all sorts of violations, and that the integrity of the community's covenants was at stake. 2 weeks before the hearing, something unexpected happened. I received a call from a man named Daniel Morris who introduced himself as a member of the HOA board. "Mr. Haywood, I want to apologize," he said. "I'm one of 5 board members, and I voted against your violation initially. I was outvoted 3-2. Patricia pushed this through, and I think she's wrong. I appreciate you saying that. I'm calling because I think you should know what's really going on. Patricia lives directly across from the entrance to your street. She can't actually see your woodpile from her house. Diane Mitchell, who supposedly complained, is Patricia's best friend. They go to the same church, have lunch together every week. I think Patricia put Diane up to complaining so she'd have grounds to cite you. Why would she do that? Daniel sighed. Honestly, I think you intimidate her. You bought the biggest property in the neighborhood. You're educated, successful. You don't come to HOA meetings or community events. Patricia likes people she can control, and you're not that person. The woodpile was just an excuse. This revelation added a new dimension to the situation. It wasn't really about the woodpile at all. It was about control and ego. Will you testify to this? I asked. I can't. I'm still on the board and it would create a huge conflict, but I wanted you to know. And I wanted to tell you that 2 other board members are having second thoughts. If this goes badly in court, there's going to be a push to remove Patricia as president. The hearing was held in the Albemarle County Circuit Court on a Tuesday morning. I wore a suit and tie, feeling nervous despite Michael's reassurances. Patricia Harmon was there with the HOA's attorney, a stern-looking man in his 60s named Robert Feldman. Several other HOA board members sat in the gallery, along with a handful of curious neighbors. The judge was Carolyn Mitchell, a woman in her 50s with gray hair pulled back in a bun and sharp, intelligent eyes. She reviewed the briefs before the hearing started, occasionally making notes. This is a petition for declaratory judgment and injunctive relief, Judge Mitchell began. Mr. Crane, you represent the petitioner, Mr. Haywood. Yes, Your Honor. And Mr. Feldman represents the Meadowbrook Estates Homeowner Association. Correct, Your Honor. Mr. Crane, make your case. Michael stood and launched into our argument. He outlined the property's agricultural designation, the protections under Virginia's Right to Farm Act, and the legitimate agricultural purpose of the firewood storage. He presented the expert testimony, Bill Henderson's statement, and my documentation of the orchard restoration plans. The Virginia Right to Farm Act exists specifically to prevent situations like this, Michael argued. Mr. Haywood has property with a legitimate agricultural use. Managing that property includes removing dead and diseased trees, processing that wood, and storing it for personal use and land management. The HOA is attempting to restrict a protected agricultural activity. This violates state law and exceeds the HOA's authority. Mr. Feldman countered with the HOA's position. He argued that the covenants were clear, that I'd agreed to them when purchasing my property, and that allowing my violation would undermine the entire covenant structure. If we allow Mr. Haywood to store firewood in violation of our covenants, Feldman said, what's to stop another homeowner from claiming agricultural exemption for storing farm equipment, or livestock, or any number of activities that are clearly inappropriate for a residential community? Judge Mitchell listened to both sides, occasionally asking pointed questions. She seemed particularly interested in the agricultural designation of my property and the specifics of Virginia law. Mr. Feldman, she said at one point, is there any evidence that Mr. Haywood's firewood storage has actually impacted property values or created a legitimate nuisance? The potential impact on property values is sufficient grounds for enforcement, Your Honor. Potential impact. Do you have an appraisal or any concrete evidence? We have the testimony of neighbors who find it unsightly. One neighbor, according to the record. And that neighbor is friends with your HOA president, correct? Feldman hesitated. I'm not aware of the nature of their relationship, Your Honor. Judge Mitchell looked skeptical. She turned to Michael. Mr. Crane, walk me through the agricultural designation again. How does firewood storage specifically relate to orchard management? Michael explained how removing dead trees was essential orchard maintenance, how the wood needed to be processed and stored for proper seasoning, and how many orchard owners used wood for heating, land clearing, and other agricultural purposes. Mr. Haywood also heats his home partially with wood, Michael added. This is a practical use directly connected to living on and managing agricultural property. After both sides presented their arguments, Judge Mitchell called a brief recess. 20 minutes later, we reconvened. I've reviewed the briefs, the testimony, and the applicable law, Judge Mitchell said. This case presents an interesting conflict between private covenant enforcement and state agricultural protections. However, the law is relatively clear. Virginia's Right to Farm Act provides broad protections for agricultural activities on property with legitimate agricultural uses. Mr. Haywood's property has been designated agricultural for tax purposes for decades. The orchard, while not currently in production, remains agricultural land. Mr. Haywood has demonstrated credible plans to restore and manage that orchard. Firewood storage, particularly wood derived from managing the orchard, is a reasonable and normal agricultural activity. I felt a surge of relief, but Judge Mitchell wasn't finished. Furthermore, I find the HOA's enforcement in this case to be arbitrary and potentially retaliatory. Only one neighbor allegedly complained, and that complaint appears to have been solicited. The woodpile is not visible from public areas and does not create an objective nuisance. The HOA covenants, while valid, cannot override state law protections for agricultural activities. Therefore, I'm granting the petitioner's request for declaratory judgment. The HOA's violation notice is declared invalid and unenforceable. The fines assessed are voided. Additionally, I'm awarding attorney's fees and costs to Mr. Haywood, to be paid by the HOA. Patricia Harmon's face went red. She leaned over to whisper urgently to Mr. Feldman, who held up a hand to quiet her. "Your Honor," Feldman said, standing. "The HOA respectfully requests that you reconsider the attorney's fees. This was a good faith enforcement action." Mr. Feldman, good faith would have been responding reasonably to Mr. Haywood's initial explanation of the agricultural exemption. Good faith would have been investigating the legitimacy of the complaint before assessing fines. Instead, your client escalated this dispute unnecessarily and forced Mr. Haywood to retain counsel and come to court. The fee award stands. The gavel came down and it was over. I shook Michael's hand, thanking him profusely. Patricia Harmon stormed out of the courtroom without making eye contact. Several of the neighbors who'd attended came up to congratulate me, including Rick Patterson and Susan Torres. "That was amazing," Susan said. "I wish I'd fought my fine." "Maybe you still can," I suggested. "If it was as bogus as mine, there might be grounds to challenge it." Over the next few weeks, word spread through Meadowbrook Estates about the court decision. The HOA's attorney's fees and costs totaled almost $12,000, which had to be paid from the HOA's general fund. This meant a special assessment to all homeowners to cover the shortfall. The special assessment did not make Patricia Harmon popular. At the next HOA meeting, which I actually attended for the first time, the room was packed with angry homeowners demanding to know why the board had pursued such an expensive and losing legal battle. Patricia tried to defend her actions. "We were protecting the integrity of our community standards," she said, her voice sharp. "If we don't enforce our covenants, property values will decline. You cost us all money because of a woodpile," someone shouted from the back. A woodpile that wasn't even visible from the street, another person added. Daniel Morris, the board member who'd called me, stood up. I move that we remove Patricia Harmon as HOA president and replace her with someone who will exercise better judgment. The motion was seconded immediately. The vote wasn't even close. Patricia was removed as president by a vote of 43-7. Daniel was elected to replace her. Patricia stormed out of that meeting too, and I didn't see her around the neighborhood much after that. Rumor had it she was trying to sell her house, though in the current market, who knew how long that would take? Life returned to normal for me. I continued working from home, and I actually started making good progress on the orchard restoration. I hired a professional pruner to help with the worst of the old trees, and I planted 20 new semi-dwarf apple trees in varieties suited to Virginia's climate. Gala, Fuji, Granny Smith, and some heritage varieties like Arkansas Black and Winesap. The woodpile stayed right where it was, neatly stacked and serving its purpose. Every time I carried logs into the house on a cold evening, loading them into my wood stove and feeling the warmth spread through the rooms, I thought about how close I'd come to just paying the fine and moving the wood. How easy it would have been to let Patricia Harmon bully me into compliance, but I hadn't. I'd stood up for what was right, for my property rights, and for the principle that rules should be applied fairly and reasonably. The legal battle had been stressful and expensive, even with the fee award covering most of my costs. But it had been worth it. Summer came, and my apple trees leafed out beautifully. The older trees in the orchard, properly pruned and cared for, started showing signs of recovery. I wouldn't get a significant harvest for a couple of years, but I was patient. Good things take time. One Saturday afternoon in July, I was working in the orchard, applying organic pest control spray, when Rick Patterson walked over with a cold beer for each of us. "Thought you could use a break," he said, handing me a bottle. We sat on my back porch, looking out over the orchard rows. The trees were heavy with leaves and the air smelled like grass and summer heat. "You know," Rick said, "what you did with that HOA case, it changed things around here. People aren't afraid to push back anymore when something doesn't make sense. That's good." Susan Torres filed a complaint about her fine. She's getting her money back, and Daniel has been working to revise some of the more ridiculous covenant rules. There's going to be a vote on amendments this fall. I took a sip of beer, feeling satisfied. I never wanted to be the troublemaker. I just wanted to stack my firewood and be left alone. "Sometimes standing up for yourself helps everyone," Rick said. He was right. The judge's dismissal of my case hadn't just vindicated me. It had exposed the HOA's overreach and forced a reckoning. Patricia Harmon's petty tyranny had been checked, and the community was better for it. As fall approached, I was ready for winter. My woodpile was fully seasoned, neatly stacked, and located exactly where it needed to be for convenient access. The first frost came in late October, and I lit my wood stove on a chilly evening, watching the flames dance behind the glass door. The orchard was entering dormancy, the apple trees losing their leaves and preparing for winter rest. I'd already started planning for spring, researching grafting techniques, and considering which heritage varieties I wanted to add to my collection. The HOA, under Daniel's leadership, was actually functioning reasonably. The new covenant amendments passed, clarifying language, removing overly restrictive provisions, and adding explicit protections for agricultural activities on qualifying properties. My case was specifically mentioned in the new guidelines as an example of protected use. I even received an apology from Diane Mitchell, Patricia's friend who'd supposedly complained about my woodpile. She stopped by one afternoon, looking embarrassed. "I wanted to say I'm sorry," she told me at my front door. Patricia asked me to complain about your wood, said it was setting a bad precedent. I went along with it because she's my friend, but it wasn't right. Your woodpile doesn't bother me at all. I appreciated her honesty. Thanks for telling me. No hard feelings. She left, and I went back to my work. The incident was behind me, but the lessons remained. I'd learned that HOA covenants, while legally binding, weren't absolute. State law, property rights, and basic fairness still mattered. I'd learned that standing up to bullies, even when it's expensive and stressful, sometimes needs to be done. Most importantly, I'd learned that my community was full of reasonable people who just wanted to live their lives without unnecessary interference. Patricia Harmon had been an aberration, someone who'd let a small amount of power go to her head. With her gone, Meadowbrook Estates was actually becoming the kind of neighborhood it had always claimed to be. A place where people could make a home, pursue their interests, and be left in peace as long as they weren't harming anyone. Winter settled in fully by December. Snow fell on the orchard, coating the dormant apple trees and my woodpile in white. I kept the wood stove burning almost daily, the heat supplementing my electric heating and keeping my power bills reasonable. Every log I burned represented not just warmth, but victory. A small, personal victory over arbitrary authority and petty tyranny. I thought sometimes about what would have happened if I just paid the fine, moved the wood, and let Patricia have her way. I'd have spent the winter frustrated, resentful, and probably looking for a new place to live. Instead, I was content, secure in my property rights, and actually looking forward to years of restoring this orchard and being part of this community. The legal principle established by my case had implications beyond just me and my firewood. Other homeowners in HOAs across Virginia now had precedent to point to when asserting agricultural exemptions. The balance of power between HOAs and homeowners had shifted slightly, just enough to remind everyone that covenants serve the community, not the other way around. Spring arrived and the apple trees blossomed. The orchard, which had looked so tired and neglected when I'd bought it, was coming back to life. White and pink blossoms covered the trees, and bees hummed through the branches. I'd installed several beehives at the edge of the orchard, both to help with pollination and to harvest honey. Another agricultural activity, another connection to the land. The young trees I'd planted were thriving. They wouldn't bear fruit for another year or two, but they were growing strong and healthy. I spent hours in the orchard, pruning, fertilizing, managing pests organically, and just enjoying the peaceful work of cultivation. The woodpile needed replenishing, so I spent several weekends that spring cutting and splitting more dead trees from the orchard. Each tree I removed made room for the healthy trees to thrive. Each log I split and stacked was another small act of defiance against those who tried to tell me I couldn't manage my property as I saw fit. I saw Patricia Harmon one last time, in early June. She was showing her house to prospective buyers, and they happened to drive past while I was working in the orchard. Our eyes met briefly. She looked away first, and I went back to my work. Her house sold in July, and she moved away. I never knew where she went, and I didn't particularly care. Meadowbrook Estates was better without her particular brand of enforcement. The community thrived under Daniel's leadership. The HOA focused on actual maintenance, organizing neighborhood events, and handling legitimate issues like road repair and common area upkeep. The atmosphere changed from one of fear and compliance to one of cooperation and mutual respect. Other neighbors started pursuing their own projects without fear of arbitrary citations. Someone started a small vegetable garden that technically violated the old landscaping rules but was allowed under the new amendments. Another neighbor built a workshop in their backyard, properly designed and positioned, without harassment. The precedent from my case rippled outward. Michael Crane told me he'd been contacted by several other homeowners in different neighborhoods dealing with similar HOA disputes. He was building a practice around property rights and agricultural exemptions, using my case as a template. By the second year after the court decision, life had fully normalized. My orchard was productive, yielding enough apples for my own use, giving to neighbors, and even selling a bit at the local farmers market. The agricultural designation on my property was no longer just a tax benefit. It was a living, working reality. I'd become unexpectedly involved in the community, serving on a couple of HOA committees and helping to review proposed covenant changes. My expertise in property rights and my experience with the legal system made me a valuable resource. Who would have thought that getting cited for a woodpile would lead to me becoming an active community member? Rick Patterson and I became close friends. We'd barbecue on weekends, share beers on each other's porches, and help each other with projects. He helped me build a proper wood shed to protect my firewood even better, and I helped him install a new fence around his garden. Susan Torres and I connected over our shared experience with Patricia's overreach. She'd successfully gotten her fine reversed, and the precedent from my case had been instrumental. We occasionally met for coffee, swapping stories about HOA absurdity, and celebrating our small victories over bureaucratic nonsense. The woodpile that started everything remained a fixture of my property. I'd eventually built a 3-sided shed to keep it covered and organized, but it stayed in the same location where I'd first stacked it. Every time I looked at it, I felt a sense of satisfaction. Not because I'd won a legal battle, though that was part of it, but because I'd stood up for something important: the right to use my property reasonably, the right to question arbitrary authority, and the right to live my life without needless interference. Years passed. The apple orchard became well known in the area. I started offering you-pick days in the fall, where families could come harvest their own apples. Kids would run between the trees, filling baskets with Honeycrisp and Gala apples, while their parents enjoyed the peaceful rural setting just minutes from suburban Charlottesville. The orchard became a community asset, something that raised property values far more than Patricia's strict enforcement ever could have. Homebuyers specifically sought out Meadowbrook Estates because of its unique character, the blend of suburban convenience and agricultural heritage. I never forgot the lessons from that conflict. When I served on HOA committees, I always pushed for reasonable enforcement, for understanding context and individual circumstances before issuing citations. I advocated for clear, specific rules rather than vague standards that could be weaponized by petty tyrants. The judge's dismissal of my case was framed and hung in my home office, not out of ego, but as a reminder. A reminder that laws exist to protect people, that property rights matter, and that sometimes you have to fight for what's right even when it would be easier to just give in. My wood stove still heats my home every winter. The firewood, seasoned and ready, sits in its shed waiting for cold evenings. The orchard continues to produce, year after year, a living testament to the agricultural heritage of the land. And Meadowbrook Estates, freed from Patricia Harmon's iron grip, became the kind of community it always should have been. A place where people could build lives, pursue their interests, and coexist peacefully with their neighbors. All because I refused to move a woodpile and had the determination to prove I was right. The whole experience changed me in subtle ways. I became more confident, more willing to speak up when something seemed wrong. I became more involved in local politics, attending county meetings and advocating for property rights and reasonable regulation. My case was even cited in a state legislative session when discussing HOA reform legislation. But mostly, I just enjoyed my life. The orchard, the woodpile, the quiet satisfaction of working with my hands and living close to the land. The friendships I'd built, the community I'd helped improve, the precedent I'd set for others facing similar struggles. On cool autumn evenings, I'd sit on my back porch with a glass of apple cider pressed from my own trees, watching the sun set behind the orchard. The woodpile would be visible in the fading light, neatly stacked and ready for winter. And I'd think about how a simple thing, storing firewood on my own property, had led to such a significant journey. The judge had been right to dismiss the case. Firewood storage was agricultural use, protected by law, and no HOA covenant could override that protection. But beyond the legal technicalities, there was a deeper truth. People should be free to use their property reasonably without facing harassment from busybodies with too much time and too little perspective. Patricia Harmon had tried to use the HOA as a weapon to impose her vision of how the neighborhood should look. She'd failed, and in failing, she'd inadvertently strengthened property rights for everyone. The law had worked the way it was supposed to, protecting the reasonable use of land while limiting the power of private agreements to override state protections. As I sat there in the gathering darkness, the first stars appearing overhead, I felt grateful. Grateful for the property I owned, for the orchard I was restoring, for the community that had rallied around fairness and common sense. Grateful for judges who understood the law and lawyers who fought for their clients. Grateful for neighbors who became friends and for the hard lessons that made me stronger. The woodpile remained, exactly where it had always been. A simple stack of cut and split logs, representing heat and light and comfort. But also representing something more. The enduring principle that a man's home is his castle, that property rights matter, and that sometimes the smallest battles are worth fighting because they establish the biggest principles. And in the end, that's what it was all about. Not just firewood, not just an HOA dispute, but the fundamental question of who gets to decide how we live our lives. The answer, as Judge Mitchell had affirmed, was that we do, within the boundaries of reasonable law and mutual respect. Not petty bureaucrats with clipboards and measuring tapes. Not HOA presidents on power trips. Us, the people who own the land, who work the soil, who build our lives one log at a time.